we try to understand how the climate crisis impacts global poverty and what we can and should do in order to tackle both the climate crisis and global poverty. And so in this context, we are grateful to host today 5 inspiring speakers who are going to share with us what they do in order to tackle the climate crisis. And so without further ado, let's turn to the first speaker, Julia Olson. Julia, the stage is yours, please.
All right. Thank you, everybody. And I want to thank Thomas in particular for inviting us to speak today, and for all the conference organizers for putting this together. It's such an important topic, and all the topics that the Build Back Better conference is covering this year. So I'm going to share my screen. All right, can everybody see that? The slide, great. So I am here, I'm Julia Olson, I'm the Executive Director and Chief Legal Counsel of our Children's Trust. And with me today, who will speak at the latter part of our presentation, is Matt Dos Santos, who is our Managing Attorney and also has connections to Brazil, which they will tell you about. I'm going to start by just telling you a little bit about our Children's Trust and our background. We began this work 10 years ago. And at the time that I founded our Children's Trust, climate change was not thought of as a human rights issue. I think a lot of the human rights organizations around the world hadn't really connected this crisis around our climate system as being one that was about the fundamental rights of people and children. And when we founded the organization, we knew that children needed legal representation on this issue. Young people are really the innocent ones in this crisis that we face. They are born into the crisis and they will endure it, and they will clean up long after the adults living today are gone. And of course, the disenfranchised youth who come from communities that are disproportionately harmed by climate change, including Indigenous communities and communities of color, those frontline communities and the children among them are really the ones who will bear the brunt of this crisis. And so if you think back to 2010, it was a time when youth were activated. So I knew many youth and organizations that were marching in the streets. They understood that this crisis was going to impact their lives and their futures, their abilities to have families. I met many young people who were trying to speak to politicians and going to meetings and raising their voices in all the ways they knew how. And they were still, I think, largely invisible and not being heard by those in power. And it's important for adults to remember that most children, a huge, population on this planet, can't vote and don't have political rights. And so we founded the organization to really give young people a voice in this crisis and allow them to be able to go to the branch of government where they have to be heard, and that's the courts. Let's see. Sorry, my little shifter is not working here. There we go. So at our Children's Trust, we have 3 main principles. The first is that we, as the only law firm representing young people, it is our single mission to really elevate the voice of youth and future generations for climate rights. In doing that, we only advocate for science-based and legally enforceable systemic remedies in court. And we use basic human rights, those unalienable fundamental rights that we all hold, to bring our cases to the courts. And so the case that really illustrates this approach in law to dealing with the climate crisis is our landmark case, Juliana versus the United States. It's the one that's gotten the most media attention. And while this case is against the government that is the biggest polluter in the world and the one most responsible for the cumulative emissions that have caused the climate crisis, the United States, we have also brought cases on behalf of youth in cases or other types of legal actions in all 50 states across the United States. And we've been helping young people around the world to also sue their governments. But I will share with you first the story of Juliana. So, like all of our cases, this is not just a case about the climate crisis. It is at its core a children's case. And what the 21 young plaintiffs in the Juliana litigation are arguing is that they have rights to life, rights to liberty and personal security. They have rights to equal protection under the law, to not be treated as less than the adults who have come before them and live today. They're also arguing that there are natural resources that are so essential to human life that they are protected by a doctrine called the public trust doctrine. And those resources include our air, our waters, our oceans, and our shorelines, and essentially our climate system. And that governments around the world, including the United States, has an obligation to protect those resources in trust for these young people, but also for future generations. So this case was filed in 2015 against the Obama administration. And it has had many, many twists and turns and a lot of complicated legal procedures that I won't go into. But I'm going to highlight some of the key moments in the case and bring you up to speed to where we are today. So in 2016, the trial judge in the case issued one of the first really important rulings, which said that the youth could go to trial. They could bring their case against the government and be heard in court. And importantly, she wrote that she had no doubt that the right to a climate system capable of sustaining human life is fundamental to a free and ordered society. And that was a really important declaration of the law in the United States. It was the first time that a court had said that the US Constitution, in protecting people's right to life and liberty, that implicitly includes the right to a climate system that is not being essentially destroyed by our government. So after that decision, we were preparing to go to trial. We went up to the Supreme Court twice and beat the Trump administration, which had become defendants in the case. And we were about a week away from trial when the courts decided that they should hear the case on what's called an interlocutory appeal or an early appeal before the evidence has really been fully presented. And so the three key questions that our intermediary court, our Court of Appeal, was considering were, can children and youth even go to court? Do they have access to justice, to have their constitutional claims heard against their government? And that's a question of standing. And then the second question was, does the court have a duty to hear the case? Can the court do anything in light of the evidence that the youth are being harmed by their government? And then the third sort of big picture question about the different roles of the different branches of government is a question about the separation of powers. And the Trump administration had argued that the political branches can do whatever they want around climate change and energy policy, and there's nothing the court can do to check that exercise of power. And the way I think of that question is, does the political majority who are in power get to make decisions to destroy the climate system and continue to perpetuate the crisis? And do those decisions get to go unchecked? And the clear answer in our minds is, when you have a constitutional democracy, they don't get to go unchecked, because it's the duty of the courts to really provide that check and protect our rights when the other branches do things that undermine and deprive us of our rights. So we argued this case in the summer of 2019 before the Court of Appeals. And in January of this year, we received a decision that was a 2-to-1 decision against us. The majority, so a 3-judge panel, and the majority in the Juliana panel on appeal made all kinds of really important, tremendous findings in our favor. In fact, when you read the opinion, it looks like the plaintiffs are winning. So I'll just point out a few of those here. So first, the court said that there was this substantial evidentiary record documenting that the federal government has long promoted fossil fuel use, despite knowing that it can cause catastrophic climate change, and that the failure to change that existing policy, which is essentially the energy policy of the United States, that it would hasten an environmental apocalypse. The majority found that the United States is expanding oil and gas extraction 4 times faster than any other nation. And the dissenting judge, who would have ruled in our favor, agreed with the majority and said this was an existential threat that was actively backed by the government. And those determinations of the court were based on the evidence that was before the court at the time of this appeal, even though there hadn't been a full trial to evaluate the evidence. And, you know, one thing that is really important about our work is, particularly when we are suing governments like the United States, the perpetrators of this crisis, we're looking at not government's failure to act on climate change. We're really looking at the question of, what have governments done to actually perpetuate and contribute to this crisis? And this chart, I think, is really illustrative. It shows, going back to President Truman and President Eisenhower, some of the earliest presidents in the United States who were beginning to understand about the climate crisis issue. We have evidence going back over 50 years that the United States government was well aware that if we continued burning fossil fuels, that we would have a resulting climate crisis. And you can see that across history, every president continued to increase the risks and add to those carbon emissions that are causing climate change. And what people don't always understand is that even under President Obama, and then of course under President Trump, the US really became the top oil and gas producer in the world. And yes, our coal production decreased slightly, but we more than made up for that decline in our increase in gas production. And so now the question, and we've put a little picture of President-elect Joe Biden on the right-hand corner, because the question is, will he change that legacy and do something different, or will he be another in a line of presidents that takes the same approach? So all of that government conduct has had real consequences. And the court made some other really important determinations based on the evidence, including saying that extreme heat that is melting the polar ice caps could cause sea levels to rise 15 to 30 feet by 2100. The court looked really closely at, looked really closely at the youth's injuries that were being caused by the conduct of the government and the resulting climate crisis. And some of the core types of injuries in the case that we've brought forward are the medical conditions that are being exacerbated. So several of the youth have asthma. They have increased allergies from the elevated levels of pollen. They've had damage to their property, including floods from hurricanes and sea level rise. And then also psychological harm, which is afflicting a lot of young people. The court said, so these are profound rulings and statements in the majority opinion that you don't see in ordinary case law. And this was one of, I think, the most powerful, that the problem is approaching the point of no return. Absent some action, the destabilizing climate will bury cities, spawn life-threatening natural disasters, and jeopardize critical food and water supplies. So I put in these pictures of the fires that the West Coast of the United States experienced this year. I know that there are other countries around the world that are also very familiar with fires, including Brazil and Australia, and the increased incidence of drought, and then these catastrophic fires that are only getting worse. This is one of our plaintiffs, Alex, on his farm in Southern Oregon. And this was a picture from this summer in September when fires, I'm sure as many of you know, the fires raged, and our air was some of the most dangerous, unhealthy air in the world for a period of weeks. And, one thing that is, I think, just a real profound change in the part of the world we live in is back in the 1970s when I was born, the wildfire season in the Northwest was about 20 days. And now it's over 120 days. And so the season just keeps lengthening and lengthening. And of course, the fires are getting worse and worse. And so all of this is part of the body of evidence that we have brought forward in the Juliana litigation. And from there, looking at the impacts of climate crisis, we then look at, well, what is the solution? What is the remedy in these cases? And so I want to talk a bit about that principle that our Children's Trust has, which is about using the best available science in our cases and really seeking those science-based remedies. So there's abundant science now that really started from Dr. James Hansen's transformative work in the 1980s and 90s, where he was beginning to look at the question of, what is the level of carbon dioxide in the atmosphere that really begins to shift how our system responds? And when do we get outside of the energy balance that has created this really livable, blissful planetary system that has allowed humans to thrive and develop? And what the evidence shows, both in terms of protecting the climate system itself and in protecting our ocean life, and particularly the coral reefs, is that when atmospheric carbon dioxide exceeded 350 parts per million, that's really when the system started getting out of whack. And all of the experts that we're really lucky to work with tell us that at a minimum, we really need to aim to get back to that level of 350 parts per million of atmospheric carbon dioxide by the end of the century. And then in the next century, we may even need to go below that. And so all of our work is really tiered to that critical number. And for those who don't know, 350 parts per million corresponds to about a 1 degree Celsius rise in warming, whereas numbers like 450 parts per million correspond with a 2 degrees Celsius rise in warming. And so just to summarize the science piece, because it's really core to our work, when we're advocating for legal standards to protect the climate for young people, we are seeking standards that are science-based. And so again, we're arguing for 350, not 400 or 450. We believe, based on just real world observations of what's happening with the climate system today and its impacts already, that the 1 degree Celsius of warming that we've already endured is too much, and that we shouldn't allow the law to sanction a rise in the Earth's temperature of 1.5 or 2 degrees Celsius above pre-industrial levels, that the law shouldn't do that. You know, we may miss the mark, but we shouldn't sanction those numbers in law. And then again, after 2100, the numbers may shift and we may know more and have to revisit what is actually safe for humanity. The good news about all of this is we also work with experts on the solution side, the energy transition side. And what's been remarkable in the past 5 years of litigating the Juliana litigation is that the costs of decarbonizing our energy systems just continues to go down. And so this is a graph that shows what decarbonization would cost for the state of Florida in the United States. I don't have the specific graphic for the United States as a whole, but the analysis is virtually the same. And so if you look at the period from 1990 to 2020, the cost of energy as a percentage of gross domestic product really fluctuates. And, you know, some of the peaks that you see in the historical part of the graph reflect things like significant changes in prices of oil, or, you know, wars and conflict that cause those prices to go up significantly. And what you see on the right side of this graphic is that when you decarbonize, when you move away from fossil fuels as our energy supply source, whether you do that through 100% renewable energy, you do it through different uses of biomass. The experts who have done this analysis, they ran many different scenarios to show that it's possible to transition off of fossil fuels using a lot of different forms of energy. And no matter how you do it, you basically get low costs compared to historic costs. And the other thing you get is you get this leveling off of the fluctuations that we've seen historically in energy costs. And so I think this is a really important part of the story that often goes misreported. There's a lot of confusion about what it will cost to transition away from fossil fuels. And the reality is that we already spend trillions of dollars on energy, you know, and the percentage of money we spend on energy as a component of our gross domestic product, not just in the US, but everywhere, is a lot. We spend a lot of money, but right now we're investing it in sources of energy that are really destroying the planet. And so we need to shift those investments to obviously clean energy. And it's really good news that for consumers, the costs are going to be on the lower end of what they've been historically, and they're going to be steady. So that's the practical side of the remedy. Tying that back into, well, what can be done through litigation brought by youth? This is, again, specific to the US case, the Juliana litigation. But what courts can do they can do three really big things. First, they can declare the fundamental constitutional rights or the human rights of children. And they can set those standards for climate protection so that all government conduct has to adhere to those constitutional standards. And, it's like the analog in the US court system that we often talk about and that we've gained a lot of inspiration from is the civil rights litigation. So thinking about Brown versus the Board of Education in 1954, when the US Supreme Court said it was no longer constitutional to have segregated public schools, that segregation violated the right to liberty and equal protection of the law that young people had. And that declaration of law, well, it hasn't been perfectly implemented in the United States. It was really an important moment to declare that could no longer happen and that governments could no longer sanction that. The second thing courts can do is they can order remedial plans. So one of the things I've seen in this work over the last 10 years that's really been lacking are those comprehensive plans that governments need to put together in order to integrate systems like transportation and electricity. So what we see happening in a lot of different places are laws that are requiring 100% renewable energy, for example. But those laws often are only pertaining to the electricity sector, and they're not pertaining to transportation. And when you think about a post-fossil world, what we're really talking about is an electrified world, a world where we electrify transportation, we electrify industrial processes. We're no longer burning fossils in order to create energy. And in order to do that effectively, you need plans that integrate all of these systems in different energy sectors. So a court can order a plan that the government would then prepare and implement. The third thing that courts can do is courts can stop the conduct that they are engaged in that is worsening the climate crisis. And these are called injunctions. So government can put an end, courts can put an end to government expanding fossil fuel extraction. Courts can end deforestation. Courts can end the infrastructure that's necessary for ongoing fossil fuel development. All those things that governments approve can also be stopped by the court. And then finally, the other thing that can happen in litigation is there can be settlement agreements. So right now we're in an interesting time where the Trump administration will hopefully soon be leaving Washington, D.C., and we'll have a new president and a new administration. And one of the things that President Biden could do is actually come to the settlement table and talk about what can be done in order to resolve the plaintiff's claims against the United States government. And we're hopeful that we will see some movement in that direction. But meanwhile, just to tie up the Juliana litigation, we, in March, after receiving the adverse decision, that 2-to-1 decision from the Court of Appeals, we filed what's called a petition for onbank rehearing. And all that is we're asking a larger number of judges, it would be 11 judges who sit on the Court of Appeals, to rehear the youth's case and correct the errors that we believe were made by the Ninth Circuit in saying that the youth have been harmed, the government has caused it, but the court can't do anything. And that's the piece that we're hoping that a full panel of the Ninth Circuit will fix. So our Children's Trust, as I said, we have cases at the state level in the United States. I've listed some of those here. There's a lot of text, don't worry about it, but we have cases in different stages of proceeding in the United States, and we're growing those cases as well to target other states on behalf of youth. And we are working globally. And before I turn it over to Matt, I just wanted to highlight a couple of cases. So this case is La Rose versus Her Majesty the Queen. It's a case brought by, I think it's 16 youth, Canadian youth, including Indigenous Canadian youth, against the federal government of Canada. And it really mirrors the same types of claims that are brought in the Juliana litigation. So this case is right now headed up to the Court of Appeals after an adverse decision by a lower court judge. So we'll be seeing that proceed in the Canadian Court of Appeals likely in this winter or early spring. And the question there is again, do the courts have a role to play in reviewing the conduct of the other branches of the Canadian government and reviewing the laws that are perpetuating the deep fossil fuel extraction industry that is happening in Canada? Meanwhile, there's two other youth-led climate litigation efforts in Canada. And just yesterday, one of them got a really beautiful positive ruling from another lower court judge. That case is challenging the conduct of one province in Canada, but we're excited that that case is going to be moving forward. And then I just wanted to mention this because it's been happening over the past week. So in the early part of our work at our Children's Trust, we worked with a lawyer in Norway who went back to Norway after being at a conference with us and drafted an amendment to the Norwegian Constitution. And that Article 112 basically codified in the Norwegian Constitution this right to public trust resources, the right to have an environment that would sustain life and that would protect future generations. And based on that constitutional amendment, Greenpeace and a youth organization called Nature and Youth filed suit against the government for its Arctic oil development. And that case has worked its way through the courts. And just this past week, the Norwegian Supreme Court, the full court, I think it was a panel of 16 or 17 justices, spent 7 days hearing argument in this case and hearing evidence about whether it's constitutional for Norway to continue to develop the oil and gas resources in the Arctic. So really big case, really important. And we look forward to seeing how that court rules, hopefully in favor of the youth. This is just a map to show how widespread youth climate litigation has become in the last 10 years since we started this. And remember, at the time, back in the early 2000s, climate litigation was not being brought as a rights-based type of litigation. So human rights just really weren't a component of it. And now you can see in all of these cases, and these are just youth-led cases. These don't include all of the cases on behalf of other NGOs or other adult citizens or seniors who have brought climate litigation in the last decade. This is just young people rising up, and it's really inspiring and exciting to see. So I'm going to end there and turn it over to Matt. And thank you.
Bom dia e boa tarde. Meu nome é Matt dos Santos. Eu sou advogado senior de OCT, Our Children's Trust, e estou muito grato pela oportunidade de falar com você sobre o trabalho global da OCT e as oportunidades que vamos para desenvolver um caso constitucional no Brasil em nome da juventude brasileira. Eu vou apresentar em inglês, mas queria dizer olá primeiro em português. So today I'd like to discuss at a high level some of the exciting litigation that's happening around the world, including Brazil, and the possibilities that we see for the development of youth rights to a healthy environment grounded in constitutional law of the jurisdiction and the most accurate and current science available. I know Julia already discussed some of the principles that we have for partnering with organizations around the world, but our essential principles are that they be youth-led organizations and focus on the environment, and that they adhere to the best science available. So the 350 parts per million of carbon dioxide and a reduction of warming to below 1 degree. Julia mentioned quickly the constitutional case in Canada, and I want to share a little bit about our work with our partners, Defensa Ambiental do Noroeste, or DAN. This is our case in Mexico. The launch of this new case marks an important milestone for our children's trust and for youth-led climate actions, because now there are youth-led climate lawsuits that span all of North America. That case is on behalf of 15 Mexican youth from the state of Baja California, and they have filed a climate lawsuit against their federal government. The suit is called Jóvenes v. Gobierno de México. Those plaintiffs, who are between the ages of 17 and 23, ask the Mexican government to comply with its constitutional obligations and the terms of the general law on climate change, and issue regulations and public policies to properly enact that law. In recent years, climate change has reached an emergency level in Mexico, putting food, health, and access to water at risks for millions of citizens. And today, Mexico is one of the 10 countries that are collectively responsible for 73% of all greenhouse gas emissions on the planet. The main sources of emissions in the country are the generation of energy from the use of fossil fuels, much like Julia discussed in the United States, but also inappropriate techniques used in waste management and the agricultural and industrial activities in the country. Given the urgency of this crisis and the harmful impacts from climate change that they have experienced, the youth plaintiffs believe the Mexican government has an obligation to guarantee that its people have access to a healthy environment as established by their constitution. And while a general law on climate change was passed in 2012, there are still no regulations or no public policies that allow for its proper implementation. And you might ask, how can that be, right? Almost a decade later. And we learned recently why that is. So our hearing was scheduled for earlier this year, and it was delayed because of the COVID-19 crisis, as many cases were at the beginning of the year. But recently, a new concern emerged, and we learned that the court was unable to serve notice of the hearing on the agencies responsible for implementing the law on the climate change passed in 2012. As it turns out, many of these agencies appear to exist in name only, if at all. So you have to ask yourself, how can the government be protecting the environment in earnest when the very agencies supposedly set up to protect these important resources don't even exist? I suspect that we'll see more news from Mexico this year, or later this year, or very early in 2021, as we sort out how to serve notice on these agencies that have no physical address and don't even exist.
Excuse
me. No problem.
I have to be mindful of the time, just to let you know that. Okay, that's all.
Okay, thanks. And I'll just quickly talk about the Brazilian litigation, which is in some ways similar, right? There are 3 significant cases in Brazil challenging the country's use and failure to use the climate fund, Brazil's climate fund. This fund was formed by the country and other countries funding. These cases focus on money available to deal with various impacts to the environment, including climate change and deforestation. On Wednesday of this week, so just 2 days ago, through Greenpeace, another case through Greenpeace, a coalition of non-governmental organizations brought the Brazilian government to the federal Supreme Court for its active negligence to protect the Amazon and the people of Brazil. This case is seeking an immediate reduction of deforestation in 2021. The plaintiffs in that case are asking for an 80% reduction in deforestation this next year. And that case is very similar to 2 other cases already filed in Brazil, all trying to ensure that money in Brazil's Green Climate Fund or Climate Fund or the Amazon Fund are used to address climate change and protect the remaining forests from deforestation. One of the things that we think is most exciting about Brazil is that Brazil's constitution is one of the most expansive in the world in how it articulates protections of human rights, including the rights of children and indigenous people. Its protections, we believe, are poised for the kind of litigation we at Our Children's Trust support globally, of protecting young people's rights to a safe climate. For example, Article 225 is the right to an ecologically balanced environment. It's the government's obligation to protect Brazil's environment for present and future generations. And we're very excited about the potential for working in Brazil because the courts, despite some of the changes to the presidency in Brazil, the courts have often expressed their independence. And over the past 10 years, we've overwhelmingly seen that people are dedicated to climate action and justice. And youth and indigenous communities are rising up in Brazil. So we have been exploring Brazil and pathways to establish stronger constitutional protections for youth around climate change, including conversations with regional groups like AIDA and other Brazilian organizations and attorneys to evaluate the pathways for youth NGOs to advocate for their climate rights in Brazil. And I know we're running short on time and I want to give folks opportunities to ask questions. So I will just close by saying, thank you so much for inviting us to be here. And if you'd like to know more about our litigation and how you could participate in our litigation, please reach out to us at our email, which I think will be available. But just in case I'm going to say it, it's info@ourchildrenstrust.com or .org, sorry.
Thank you very much, Julia and Matt, for this inspiring work that you and your colleagues and youth leaders are doing around the world. Now let's have a section of a conversation between all of us who are here. And I would like to invite you all to take advantage of the fact that we do have people who translate between Portuguese to English. And so if you feel comfortable, you can either use the chat or open up your mic and say what you have to say with your own voice. If you want to say something with your mic, please open it and I'll call you in the order in which I see the mics being opened. I saw already 2 questions, so I would like to invite those who wrote the questions to say it out loud with your voice. And if you don't feel comfortable, I'll read your questions. Okay, so I see in the chat a question, but I cannot see anymore who wrote it. So I'm sorry about that. And it's for you, Julia. Congratulations on the excellent work and exhibition. I have a question. How can climate change be transformed into positive investment and innovation opportunities with green transformation in mind?
Yeah, thank you for that question. And I tried to type an answer, and I don't know if it's going through, but I'll just reiterate that here. So in the 2020s, you know, this decade, the types of investments that are really needed are to begin large-scale electrification processes in both the transportation sector and then in buildings. We need to ramp up construction of renewable energy generation and upgrade transmission capacity. So transmission lines need to be upgraded in order to accommodate more load in the systems. And so there's a lot of sort of basic infrastructure upgrades and investments that are needed. And then the piloting of new technologies. There are great companies, and even the US government's NASA program is looking at electric airplanes, for example. And so really investing in electrification is what's key right now. And I think there are a lot of job opportunities and job training that can come with that as we move some of the workforce out of the fossil energy sectors and more towards the renewable energy sectors. That's what really needs to happen in the 2020s. And again, in terms of how that happens, those investments can come from the private sector. They can also come from the public sector and from government investment. And the important thing to remember is that this isn't money that's just, it isn't like this becomes taxpayer money that's just given away, right? These are investments and there's a return on these investments. And so we're hoping that we will begin to see that happening in the United States and elsewhere, you know, even more over the course of this decade.
Thank you, Julia. And there's another question, but again, now I can't see who wrote it. So if those of you want to speak up, you are most welcome to open up your mic. But if you don't feel comfortable, that's fine as well. I'll just wait for a second, and if nobody opens the mic, I'll read the question.
Yeah, I mean, there was one other question about protected areas and how protected areas, I think, can be used to address this problem and the Convention on Biological Diversity. And there are lawyers around the world who are looking at bringing litigation to protect World Heritage Sites, for example. We've been talking to lawyers both in Australia and Ecuador about really important World Heritage Sites like the Great Barrier Reef or the Galapagos, for example. And I think what's important in these cases, from my perspective, is litigation that is aimed at protecting those areas for the benefit of the areas in and of themselves or the species. That's really important litigation. It also doesn't always resonate with everybody or tell the full story. And so I think connecting the loss of those special places, whether it's a World Heritage Site or otherwise, connecting it to the human element. Why do we care about those places? Why do we want our children and our children's children to be able to experience those places and benefit from the biodiversity and the food sources and the recreation and the spiritual importance of these places for generations to come? So yes, it's really important. And I think we're going to see more of that. And I think it's important to tie to the human element as well.
Thank you. I just received a message from the support that people cannot open up their mics. And then Thomas wanted to try something. Well, Thomas, can you try to open up your mic?
Yeah, I can try. Can you hear me?
Yes, we can hear you.
Okay, so I have a question about possible downsides of litigation. So at one extreme, there is the view that you just bring a legal case and see what happens, right? The worst that can happen is you lose your case, and then somebody else can bring some other case, and you get a little publicity out of it, maybe, but if you lose, it doesn't matter so much. Another view would be to say, well, actually, a poorly conceived legal case can set back the cause because you might then have precision in the law where previously there wasn't. You create a precedent that can be a roadblock for other cases that are being brought. Now, I'm not sure whether you can answer, where do you see reality being here for all countries? It may vary from legal system to legal system, but if you could at least say something about the United States in this regard, that I think would be very helpful. How dangerous is it? Is there any danger? And how good do you really have to be in order to make headway with a legal case?
So I'll start with that answer, and then I'd love Matt to jump in with their perspective, coming from the American Civil Liberties Union and doing a lot of work where sometimes you lose before you win, just to share that perspective. But it's my view that any cases being brought on this, existential question need to be really well formed, and it's up to attorneys to bring the best possible cases to the courts. And that means having the evidence that will support your claims, having solid expert testimony, ensuring that the plaintiffs who are bringing these cases to the court can demonstrate actual harm that they are experiencing and will experience in the future. So bringing real controversies, real cases, not just symbolic cases. And so we, at our Children's Trust, we work really hard to do that. We do work with top experts around the world. We have an evidentiary record in the Juliana litigation that is tens of thousands of pages. We did deep historical research into the government's practices and conduct. For the past 50 years, we went to every presidential library to do extensive research so that we could really bring the full story to the court. And I think it is incumbent on attorneys to only bring the best cases forward, and to also, fully understand the law that you're working with, and how to build the best case. That said, if we aren't using an entire branch of government to help us solve this crisis, we are not doing our job, right? There's a reason we have 3 branches of government. And when the political branches of government have been failing us and violating our children's rights for this long, it is time for the courts to step up. And sometimes it takes a while for the courts to step up and do the right thing and act as that constitutional check on other branches. But it is vital that they do so and that they get in this game, because we need everybody. We need civil society. We need all branches of government. We need scientists. We need communicators. We need everybody in on this, because this is the crisis of our lifetime. So one branch of government does not get an out. And these are valid cases. These are not symbolic cases. These are real cases that deserve hearing and decisions. And this isn't new. So Matt, if you want to jump in and just talk about how the law evolves over time, I think that would be helpful to answer that question.
Yeah, absolutely, Julia. And thanks, Thomas, for the question. I think what Julia said is right. This isn't new, right? This idea that that courts, when can courts act? When should courts act? And whether these decisions, right, the decisions of the rights of people, individuals, should be left to a majoritarian political process. And if history is any lesson, I think that there should be a careful distinction between, as lawyers and folks looking at these cases, see wins and losses, like thinking about the distinction between whether the case was meritorious and should have won, and whether it did in fact win, right? And I say that because I think that so prior to joining as the managing attorney at our Children's Trust, I was the legal director at the American Civil Liberties Union, known in the United States as the ACLU, which is the largest nonprofit law firm working on civil rights and human rights in the United States. In fact, the ACLU appears in the United States Supreme Court more often than any other law firm in the country, except for the United States Department of Justice that represents, the United States in every action. And there I was very deeply involved in immigrant rights cases, LGBT cases, especially cases on behalf of transgender youth, and also cases on behalf of same-sex couples seeking the right to marriage before the Obergefell decision in the United States. And we had this debate. I mean, I remember, this in, about 2008, having heard from people saying, going to the Supreme Court is the wrong idea. If you do this, you could potentially set back LGBT rights for 20 years if we get a bad ruling. And the idea was, of course, right, like that there could be potential long-lasting consequences. But what I think we have seen time and time again is that there are a series of cases, and you can look at almost any civil rights case in the United States. There are a series of cases where plaintiffs with essentially the same harms and essentially the same injuries ask the court for redress and are denied, until that first case where they're granted their remedy. And at that case, you have a monumental shift in the way that the law thinks about these harms. However, it should be very clear that the people in those cases who did not win before had the same harm. And it was taking the law and the judges to catch up to where society and those people knew they were being harmed in order for their rights to be vindicated. And I think that if we were to sit passively by and not use the judiciary as a tool, we would not see our rights being vindicated, because we would not be pushing the law forward as it needs to be pushed in order for it to catch up to a society that desperately needs it to act right now.
And for two analogies there, so there's two sort of metaphors we've used in talking about this. One came from Professor Mary Wood, who has done amazing work to further the public trust doctrine in the context of climate crisis. And she used to hunt with her dad, and she would say that when you're out hunting ducks, you have to shoot ahead of the duck, and the duck will eventually catch up. But if you shoot at the duck, you'll miss. Other football fans, American football fans on our team, say it's like the quarterback throwing to the wide receiver. You don't throw at the wide receiver, you throw ahead of the wide receiver so the receiver can catch the ball when they catch up to it, right? And so the work we are doing right now, this cutting edge climate litigation work, it's shooting ahead. We are waiting for that moment when the courts will catch up and issue these landmark decisions. And we are seeing it in other countries like the Netherlands, like Colombia. It is happening, but it will never happen if the cases are not brought to the courts.
Julia and Matt, unfortunately, I'm mindful of the time, and we can continue this fascinating conversation for hours ahead as you stretch the legal system and civil society to new norms. So could we stretch the time if we just had it. And I'll conclude with your permission by saying that as an educator working with educators, with teachers and high school students, we share with them your work. work that you and your colleagues and the youth are doing. And it really and deeply inspires them and empowers them to see that civil society works in all kinds of walks of life and fronts, and everybody are doing the best that they can, and we all push for the same goal. So thank you very much for your part in this session.